Every day in the USA, people find themselves in court.
Good afternoon, everyone.
Good afternoon, Your Honor.
Your Honor.
Yes, sir. Good afternoon. All right, Mr. Watts there at the jail. Can you hear me okay?
Yeah.
All right, let's go ahead and go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus James Brent Watts. Case number 22 CR 83. The state appears by Cheryl Pierce. Defendant James Brent Watts appears in person pro se. Attorney James R. Watts appears as standby counsel. We're set today to take up a motion filed by Defendant Watts, as well as an issue raised by Attorney Watts as to what his role is as standby counsel. I thought it'd be appropriate to take that up on the record with Defendant Watts present, so everybody's on the same page as to what Attorney Watts's role is as standby counsel. And I think I'll address that first. In my vision of standby counsel, Attorney Watts would be not to provide legal advice or trial strategy, that sort of thing, but rather be there to explain trial procedure, how things work, the inner workings of a trial, from voir dire, opening statements, jury instructions, opening arguments, closing arguments, that sort of thing, procedural matters, ensuring that Defendant Watts has a fair trial, that the trials run efficiently. I don't expect that you'll participate in any examination of witnesses or address the jury in any manner. I just want it clear that you're helping with the legal type things that go on in a trial rather than strategy, because Defendant Watts has chosen to represent himself and wants to present his theory of defense himself. So that's in a nutshell kind of what I expect your role to be. Also, you might be able to provide him with some limited access to the outside world, for maybe providing some phone numbers or addresses for witnesses he might want to get in touch with. I don't expect you to be a role of private investigator or anything like that, but as Defendant Watts is in custody, if you can help him with just maybe providing some information you can get there handily, I think that would be appropriate. Also to advise him of certain rights he might have, such as his right to testify or his right to choose not to testify, those sorts of things. So Attorney Watts, does that kind of help clarify what your role will be?
Well, it does, Your Honor. And the reason I ask is, it was not very clear, and that's not necessarily the fault of the court by any means. There's very little guidance out there in the case law as to exactly what that representation means. It has always struck me that if you're not very careful, it can be a trap for an attorney to bring on 1507 or some sort of a disciplinary problem, that you're setting yourself up for that sort of problem. I don't want to be in that position. I've told Mr. Watts, James B. Watts, that I can assist in obtaining subpoenas and documents if he helps. We haven't really discussed strategy very much, to be perfectly honest. He's not really interested in hearing what I have to say in terms of strategy. So I think that helps a lot, Your Honor, as to, I've noticed some cases that have come up through the appellate system where a standby or counsel has been essentially put into the position of taking over when a defendant in the middle of a trial turns to him and says, I've done all I can, would you take over here? And I don't think that's a realistic position to be in for any attorney, to have to step in mid-trial and take over a trial. And I'm hoping very much that's not the position I'd be expected to be in should that happen.
Well, I've seen some of those cases as well, and frankly, I don't feel that that's appropriate for someone who's assisting the standby counsel. So those are what I had envisioned as your role. Let me address Defendant Watts. Do you have any questions as to the role of Attorney Watts as standby counsel?
Well, I've asked him for things and he hasn't gotten them, but I've had bad experiences with attorneys. Attorneys in the Bible are the worst people you can possibly. They're absolutely of Satan and the devil and everything else. Attorneys and lawyers are the worst people there are. They're evil. I've been screwed by them up at Chase County. They've allowed people to lie and I had to do time in prison. So I'm not going to deal with that. They're going to be put to where they need to go. Hell. I don't know of any attorneys that I can say have done good. So no, I'm not.
Mr. Watts, you're entitled to represent yourself, and that's what
Parents have committed perjury, saying because they're afraid that they're going to get in trouble for something, for me having firearms. I hid them in their house. I've always had firearms. I always will. By the laws of the heavens, laws of the universe, there's no restrictions on anybody having firearms to fight evil with. So I'm not going to deal with that. I'm not going to abide by that law. That law is purely satanic. But anyway,
Mr. Watts, we're kind of veering away from the issue of Mr. Attorney Watts's role as standby counsel. So, Ms. Pierce, do you have any comment regarding the issue of Attorney Watts's role as standby counsel?
No, I think that the court and Mr. Watts have a handle on it.
All right. The other issue I wanted to address today is a motion filed by Defendant Watts, which is titled Motion to End the No Contact Order Between Me and My Parents. So, Defendant Watts, I'll allow you to argue your motion at this time.
Well, my parents are guardians and they're also trustees of an estate. They handle my money and I need access to my money. I can't get my money and I need that polygraph. I want it for evidence. I can introduce it in court many different ways, whether it's taken that law enforcement use polygraphs for to establish probable cause or to disallow probable cause or not allow or not have probable cause, the showing of it. They can absolutely be, I can file them in with filings if nothing else. I want that polygraph taken. But anyway, I've got many filings. We're going to have to, I've got evidence. I've got to talk to arms list on my accounts there. And I've got to also call the phone companies, contact them to see what records they have and what arms list has. I've got to get responses from them. The whole idea of a preliminary hearing is to tie down evidence in that because there are absolute perjury attaches in a preliminary hearing. There don't need to be any lies or perjury like that from my parents going on the firearms not being mine or me shoving them down. I'm not going to deal with it. Now you've got a situation because the deputies told my parents that they were going to get in trouble if I had firearms, evidently. I'll have to find out exactly what all was said. They haven't wanted to tell me, or even county attorneys talking to them about me having firearms. I believe every felon needs to have firearms. The felons aren't the evil and wicked people. It's all positions of power and authority in society and governments and the wealthy that are the real evil and wicked people. The ones that are in the prisons and jails are some that have been possessed by some devils, demons, and unclean spirits at the commands of the real evil and wicked ones to try to fool everybody. The evil people are in jails and prisons. They
All
are.
right, Mr. Watts, you're kind of veering away from the motion that you filed was to allow contact between you and your parents. Do you have any more?
Yes, I
statements
do.
you'd
I've
like
got
to say?
bank records I've got to get, show my access to cash on hand. I've got phones out there I've got to get a hold of. I got a phone at the Butler County Jail I've got to get a hold of that they seized down at Leon. I need chargers to go with them, but I'm going to have to go through them and pull out different messages that I haven't deleted yet on me purchasing firearms and ammunition.
And that's information you believe your parents will be able to provide you?
They have the access to the phones down there. Also, the county attorney, I've requested paperwork listing all of the firearms and ammunition that was seized. I need to know that because I'm going to question every bit of that at the preliminary hearing. I need full list of everything that was seized of my property. And it is my property.
All right, Ms. Pierce, your response to the request for Mr. Watts to have the no contact order lifted with his parents?
Judge, quite honestly, I thought that had been lifted months ago. There was a time that he was in the hospital that we actually did a order lifting that. That was a few months ago. Also, my contact with the county jail around that time, as I recall, was that no contact order was lifted. If the jail is still operating under a assumption that it is still in place and they need some kind of written order to the same that it is not, I will be more than happy to do that. I have no problem with him having any contact with his parents. Again, I would request that all of their statements are recorded, so I don't have an issue with that. So, again, I thought that it was been lifted. That issue had been addressed a long time ago.
Okay. Do you recall when that may have occurred?
Well, when he went to the hospital required a order. And that was, that was way back.
Well, Ms. Pierce, if you're not objecting to it, then I don't think it matters at this point.
I guess my question is to the jail, and maybe I don't know if the person that's there with Mr. Watts can answer that question or not, whether or not they are still operating under the thought that there was a no contact order. But again, I don't know why they would be, because I've spoken to Mr. Reynolds about it, so I don't know if that's right. I don't know if Mr. Watts has attempted to make some kind of contact with his parents and he's being told he can't. I don't know if I don't know exactly what the circumstances are, that the reason that Mr. Watts continues to believe that there's no contact order in place.
All right.
I
Well,
I don't believe the phone's going through. I don't believe the phone allows them to answer. It needs to be checked on. But I need to make sure I have access to money for
well,
different.
the court will lift the no contact order. If the order hasn't been lifted previously, that will allow you to have contact with your parents. If you need to communicate with them by mail, if you're not able to get in touch with them by phone, you're certainly allowed to do that, Mr. Watts.
Okay. Is there any way we can have the phone checked to make sure it would connect if they will answer it.
Well, that's not something that's something the court does.
You can't order Reynolds to check the phone and make sure it'll connect.
No.
I've got to talk to them about access to those other phones out there, cell phones. And then the jail's got one, but I need to have access to them and chargers so I can go through the text messages and possible phone numbers on those too.
Okay, well, there's no contact order is lifted, so you can communicate with your parents. So, Ms. Pierce, would you be able to produce just a brief order? So we've got some. I didn't see anything that was part of the court file, just so that's part of the court record.
I will do so, Judge.
Okay, now we've already got the preliminary hearing. We've already set that. That's going to be October the 1st at 9 o'clock. That's an in-person hearing here at the.
There's no way Your Honor, there's no way I'll have my evidence by that time.
Okay, well, we've got it set, so if you're going to be seeking a continuance, you can raise that at the appropriate time. But for now, this case has been pending for a long time. We need to get it moving. We've had this date, the preliminary hearing date, set since August the 12th. So, all right, I believe that addresses the two issues the court wanted to take up today. Ms. Pierce, anything further?
No, Your Honor.
There's other filings that are in there. One is to reschedule the October 1st date and a motion, and then also, the list of the firearms and ammunition that I'll be addressing in court that they say were their property. I need those lists provided to me. And I need to have that polygraph too taken. I don't know why we haven't got situated on that.
Well, Mr. Watts, if you want to pay to have a polygraph done, you can do that. It may not even be admissible. You'd have to file a motion to.
I can still have it and use it in other court proceedings.
Well, if you want to do that, that's got to be at your own expense. The court doesn't provide funds for you to do that.
Yeah, but I don't have access to getting in touch with anybody to get that done.
Okay, well, I don't have any other motions that have been filed recently, Mr. Watts. Have you received anything, Ms. Pierce? The last one I have is the motion to end the no contact order, which was filed August 23. I haven't seen any other motions that have been filed since then.
Judge, according to what I have in my file, on September the 3rd, there was a motion that this is filed by Mr. Watts, the defendant, motion that I be given list of all my firearms and my ammunition seized from me. And then there's also another one that is, and that was done on September the 3rd at 11:47 a.m. And then there was another one that was filed September 3rd at 11:47 a.m. Motion to reschedule the October 1st date of the preliminary hearing so I can get all my evidence collected. And then, of course, the motion to end the no contact order, which was filed on August the 23rd. I think those are the ones that that I have that are the most recent filings, Judge.
All right. Angela, can you try to pull those up, please?
I've got no brief.
All right. I'm going to take a brief recess and I'm going to look these over. I would rather just take them up now.
Judge,
Can
I
you address
just,
those?
yeah, Judge, I want to clarify with the court that Mr. Reynolds, who's watching this, indicated that the no contact order was lifted that Mr. Watts and his parents have been speaking periodically on the phone. Mr. Reynolds checked the phones and the phone is not blocked, was unblocked months ago. So Mr. J.B. Watts, defendant, has had access to his parents' phone for months.
I
So
told the cell phone,
I will be more than happy to do an order lifting that no contact order as of today, but it looks like it's already been done prior.
Okay. Okay. Right, I'm gonna.
I
take a
have
brief-
not had unlimited access. There's been one or two times I talked on the cell phone just a little bit, and I was supposed to talk again, and it didn't go through.
All right, well, I'm gonna take a brief recess and review these other pending motions.
Thank you, Your Honor.
Hey, can you hear me, James?
Yes.
What,
Now, hang on. Keep in mind, everything that's said here right now is open to the internet and the public and everything else. This is
yeah,
not private.
I was just wanting to know,
James, Mr. Watt, James, did you hear me? This is not private. Okay, you understand that?
I just want to know about what had been set up on the polygraph test.
The polygraph examiner that most people use around here is an Augusta. I've not had a chance to talk to Augusta. I frankly have no idea what he costs.
Well, I have money that's been on there. I haven't been using much money that has
I
been
will
on
tell
my
you,
account. So there's plenty of money out there.
James, with
What's that?
James, polygraphs, and we touched on this before. Polygraphs are not generally admissible in court.
I can use them in other ways for filings and stuff like that to get them on the record. As in paperwork for filings and this and that, if I can't get it introduced in court. I'm questionable why it can't be introduced in when I've got people lying against me.
Because polygraphs are not reliable. They are not.
How come law enforcement uses them at times to establish whether there's probable cause or not?
Because law enforcement uses them as an investigative and interrogation technique, not as truth telling, because they don't do that.
All right, Ms. Pierce, are you still on?
Yes, sir.
All right, we'll go back on the record, same appearances as before. I now have before me a motion that I be given lists of all my firearms and ammunition seized from me, and a motion to reschedule the October 1 date of preliminary hearing. I want to address the motion regarding the firearm list at this time. Mr. Watts, I'll give you an opportunity to argue your motion. Go ahead.
Well, since I'm going to be, my parents are saying that evidently I took my own firearms and ammunition, I want to be able to question them on that and have know absolutely all the ammunition, everything that was in there by the brands, types and brands and stuff, and a list of all the firearms and everything. I should be entitled to that under discovery. I never was provided it.
Response, Ms. Pierce?
Judge, typically all that information is part of the KSO, KRO. I imagine that it is summarized or it is a part of that as well. I don't know whether he got full copies of discovery or not. I'm not familiar with exactly what it is that defense counsel provides to a an individual who is representing themselves. So I don't know that he did or he didn't get copies of all of that, but that information should be a part of that arrest document. But then again, at the same time, I do not have a problem whatsoever providing him with a list.
All right, yeah, typically I would assume that the seized property is included in the list that's usually provided in discovery, so it sounds like a list does exist. I don't know what you've been provided, Mr. Watts.
I have not been provided that. It's been absent. Everything that was seized from anywhere, I have no record of anything. I know other stuff was seized, phones and different things, probably a computer at the house down there and different things. I don't have a list of anything that was seized anywhere. No list whatsoever.
All right, Attorney Watts, is that something that you could perhaps assist him in getting a copy of the list of seized firearms and ammunition?
Your Honor, I provided to Mr. Watts the copies of the discovery documents provided to me by the state with some redaction, and frankly, given that the victims here are his parents, who obviously has intimate familiarity with. Not very many redactions. That was provided some months ago. The charge here, and the charge here is a burglary and robbery where the items that were taken were firearms. Those items taken are listed by the alleged victims. They're listed in the police report as a number of 6, 7, 8, 9, 10, 11, 12, looks like 12 firearms seized. It doesn't specify the particular firearms, or not, I shouldn't say seized, stolen. As to whether or not there is a list of firearms seized by law enforcement, I can double check and see if I can see that. I'll see if there is such a list.
Okay, well, we don't need to go have everybody go through everything now, but to the extent that this list exists, I would ask that if there were firearms seized and if there's a list of those, that be provided to Defendant Watts.
Yeah, they were seized down at Leon when I had down at Leon on me and in the truck. And then there was also the firearms down at the house. And they're accusing me of stealing my own firearms. So I need lists of those because there will be questions on those. And I also will try to go through arms list and get all the contact with people and my phones.
If the lists exist from law enforcement, then I'll order that those be provided. If in fact they do.
If I don't have access to a list, they shouldn't be allowed to say I stole it if I have no way to know what they're saying I stole.
Yeah.
I need to know the types of ammunition and how many rounds and stuff like that, so I know where the purchase was made.
All right, now we'll take up the motion to reschedule the October 1st preliminary hearing date. You've already made some comment to that regard, Mr. Watts, but go ahead if you have anything additional you'd like to say.
Well, I'm gonna have time to contact people and get all this stuff lined up, and I may have to write several letters to arms list and net 10 phones and stuff like that to try to locate information, and I'll have to probably have some way to send money for copies. So it's going to be fairly time consuming. I've also got my bank records that need to be dug out from my parents over the guardianship. They're saying I did tell her I needed those on that cell phone call that was real quick that I did get through to them, but I haven't been able to check up on that or talk to them anymore on their phone. But anyway, I need access to my bank records to show purchases. And she don't know how long it'll take her to dig those out. And I need those to evidence in court. Everything I can evidence in court, I need to get questioned and evidence so there won't be any perjury. I've had perjury to happen and put me in prison up there at Chase County. And it's not gonna happen again. I don't know why there isn't liability for perjury in all proceedings.
All right, Ms. Pierce, state's response to continuance request.
Judge, this is a 2022 case. The first appearance on this, came in on, 4/18/22. So we are well past 2 years. Now, in the interim or during that time, there's been a competency evaluation. There's been a couple of care and treatments, those kinds of things. So that has delayed the whole process as well. I understand the idea that, you know, he has things that he wishes to have in his possession for his to present his defense. I think that the court and Mr. Defense Counsel, Mr. Watts, just did talk about being able to assist Mr. Defendant Watts in obtaining some subpoenas and documents and stuff of that nature. So I think that that can be done relatively shortly. I don't have any necessarily concern. The majority of the witnesses in this case, for the most part, they are the defendant's parents. We've not had a preliminary hearing of any sort. They are elderly. You always take a chance of something of their age when we deal with people of their age, of unfortunate things occurring. And I don't want to, in balancing his, the defendant, Mr. Watts' need for an ability to accurately present his defense against this whole ideal of continuing to delay this. I would just suggest to the court that if the court is going to grant the continuance, that the court would do it and make sure that we're not too awfully far out, and that there's an order that it not be continued again unless there's extreme circumstances, and that any delay that is caused by this particular request for continuance to be against the defendant.
All right, thank you, Ms.
And I
Pierce.
know that we're not at a speedy trial situation, and that we haven't had the preliminary hearing, or that we haven't done an arraignment. So I know that that doesn't necessarily apply. However, I want it documented that he is the one that asked for, the defendant is the one that asked for the continuance.
All right, thank you, Ms. Pierce. Going back through the docket notes, way back on September 20th of 2022, almost 2 years ago, we were set for evidentiary preliminary hearing. All the state's witnesses appeared. On that date, Defendant Watts refused to make himself available for the preliminary hearing. So then it ended up having to be moved, and then there were competency exams and so forth. This case needs to go to preliminary hearing. Mr. Watts, you've had 2 years to be getting all of this stuff together, and I'm not going to continue a date that we've had set now for several months for preliminary hearing at this time. If you wish to raise another request to continue the hearing when we come back on October 1st, you're welcome to do that. But I'm not going to reschedule it for now. This case needs to move forward. We've had too many delays.
Okay, Your Honor, you should know that before, why I postponed it before, I didn't have the evidence then. I had requested evidence from attorney, James R. Watts as far as information from arms list, the phones, the list of firearms, ammunition and stuff. I had requested stuff like that before and didn't get any response to it. I should have an opportunity to try to destroy probable cause in a proceeding that perjury will be liable.
Okay, you'll have that
Because
opportunity
I-
October the 1st.
What's that?
You'll have that opportunity October the 1st.
Okay, my parents are lying and I'm need proceedings to get that under control.
All right. Well, we'll
And
see
I
everybody
also,
back
I
October the
also
1st.
need to get new glasses. I need to have an eye exam. I filed a motion that might not have gotten to the court yet, but I need to get new glasses, an eye test and new glasses for court.
Okay, I haven't seen that particular motion, but we'll take it up in due course. So, all right, Ms. Pierce, anything further?
No, Your Honor.
Mr. Watts, anything further?
No, sir.
Well, I just want to make sure that I'm going to go ahead and try to get letters off the arms list and net 10 phones and start tracking down the evidence there. And I still want that polygraph taken. I'll be using it for any and everything I can. But I need to make sure that that stuff's in the process. Even if it isn't introduced at the preliminary hearing, I still want it.
Yeah, well,
Court filings
that's on
and
you.
reviews
If
of
you want
trial.
to obtain that, you have that right. So, all right, if there's nothing further, we'll be in recess. Thank you, everyone. All right, we'll go on the record. This is in the District Court of Butler County, Kansas. Case is entitled State of Kansas versus James Brent Watts, case number 22 CR 83. Would counsel announce appearances, please?
Cheryl Pierce on behalf of the state.
Your Honor, James Watts as standby counsel for James B. Watts, who is acting pro se.
All right. That's correct. James Brent Watts is appearing pro se. He's representing himself. I scheduled this hearing today to take up several motions that have been filed by Defendant Watts. I'm just going to go through these in the order that they appear in the court file. The first one is a motion for continuance of the February 4th trial and the January 31st pretrial conference. Defendant Watts, are you still seeking a continuance of the upcoming trial?
Yeah, I have had no access to evidence. James R. Watts played a trick. He brought a phone number by me and he knows dang well that arms list won't answer a collect call. I wanted addresses and phone numbers. Now the phone numbers, if I went to Larned, I could use those up there. But anyway, I can't use them here. But anyway, I've had no access to get anything. Nothing's changed since the continuance was granted last time. I haven't even got glasses. So I can't see. And then they've also been refusing medical. The dizziness and stuff from the negative energy being inflicted to me is getting worse. But anyway, no, I have not got access to anything. I haven't even got the transcript. I wanted a copy of the transcript to go over. I need a copy of my grandfather's will. All firearms were left to me. So Dad saying that firearms on there were left to him. No, and all those firearms are newer than could possibly be left on that will. They're to be
Okay,
used.
well, you're kind of jumping around a little bit, so let's let's come back to that motion. One of the other motions that you filed is the motion for, it's titled Motion for My Required Evidence of a Copy of My Grandfather Brent Bollin's Will listing what was all left to me, including all firearms. Where is this will located?
My parents would have a copy of it. Or maybe even several, I don't know. It would be there, and what do they keep them at? Court, is it, well, I don't know. They keep them somewhere in the county building, I thought too. But anyway,
Was this a will that was admitted through a probate estate here in Butler County?
it set up a trust for me and everything. Yeah, it was an official will. And all firearms were left to me. They've always been left to me. Nothing in the way of firearms was left to Dad. I don't know what all was left to Dad, but
Well,
left to him.
I'm not sure what power the court has to produce a copy of this will when we don't know where it is.
Oh, my parents have a copy. They absolutely have a copy somewhere. I don't know where they put it. It'd be possibly in the file cabinet downstairs. Probably that's where it's at. They have a copy. I think I had one years ago, but everything's gotten changed around. I mean, they've switched houses and everything else. A lot of stuff's been thrown away. So I don't know where my copy was. I absolutely had one sent to me and everything. Went through it, and they had one.
Judge,
Go ahead, Ms. Pierce.
I believe that Mr. and Mrs. James B. Watts' mom and dad have inquired into the assistance of Mr. Gail Jensen. I notice he's not here. I don't know if that has been information that's been provided to Mr. Watts, James R. Watts. But some of what the defendant is asking for might be like the will, those kinds of things might be, we might get assistance from Mr. Jensen if in fact there is the ability to get it. I don't know anything about it. It's kind of odd that Mr. Defendant hasn't asked his parents for it. I'm sure they would be willing to provide that, but I don't think that the court has, no court nor do the state have the authority to subpoena that or to get that because it's not part of this case. But as I said, I think we've all kind of went way above and beyond in trying to assist the defendant in getting everything he needs. And I think that Mr. Jensen may be able to assist if in fact Mr. Watts's parents have in fact hired them to assist. But again, he's not here today. So, and I don't know if that's because he didn't know about this hearing because I didn't inform him because I just didn't think about it.
Okay, well, I doubt the court notified him because I had no idea that he may be assisting them in the case. Attorney Watts, do you know anything about this will?
I have not asked my parents because they're defendants here, and I don't think I've asked for stuff in the past. They haven't done nothing. So I've got also my bank records and stuff showing that my cash on hand. I asked for that a long time ago. They haven't done it. They're witnesses in this case for the prosecution. So I don't think, I think they're bothered by getting me anything. So, but stuff has been asked for.
Right, let me address Attorney Watts. Attorney Watts, do you have any knowledge about this will? And you're muted.
I would not, Your Honor. I would note that Mr. Watts has a subpoena power he would have the ability to request a subpoena, and I'm certain that as he's acting pro se, if he were to request a subpoena from the court would be glad to grant that. He could subpoena that will and send that subpoena to his parents or his parents' attorney. And under that subpoena power, they would have the obligation to provide that document if they have it. He has subpoena power for bank records. He has subpoena power for any of these documents he wishes. He simply has to issue the appropriate subpoena.
Okay, I thought I could just, I'll try that then. I'll get busy and try to subpoena stuff, but
And
uh,
Defendant Watts, the court doesn't have the authority to order your parents to produce this will. That's something that they can either hand over to you voluntarily or not. But I can't order them to produce the will.
so that's denying me evidence. I mean, if you get a court case going where everybody has the evidence as witnesses against you and they don't want to do it, that's not anything by God at all. No, you get all
Well,
people.
as Attorney Watts stated, if you issue a proper subpoena, that may be an avenue from which you could obtain this will. But barring that, I don't have the authority to order your parents to produce this will.
I've had court orders that judges have done for ordering evidence, paperwork from the court records and stuff like that. I don't know anything about not being able to order stuff. But anyway, if I do the subpoenas, I still won't have enough time. There'll still have to be a continuance. I don't think they could possibly, by the time I get it written and get it to them, they take a long time to get me my file stamp caption pages back, several weeks or more. And a lot of stuff I don't even hear back from. I've got that guardianship case that needs to be thrown out because they bluffed it through without me having any knowledge of it and denying everything on it. But anyway, I wasn't even present at the first meeting on the guardianship. Nobody was present for me.
Mr. Watts, that case is in front of a different judge and is not
Yeah.
the court today. I'm going to take up another motion that you filed. This one's titled Motion to Take Notice that Attorney James R. Watts visited me at the jail October 10th, 2024, Thursday around 2:15 p.m. and only left a phone number for arms list, which requires a regular phone as businesses will not collect inmate calls from jails. So you've touched on this before. Is there anything else you'd like to say in support of this motion?
Well, I requested addresses and phone numbers. Like I said, if I go to Larner, and that could very well happen again, I can use phone numbers up there. So for me to have them, but here I would have to have the address and enough time to get all correspondence.
Do you have an address, Attorney Watts, to go along with the phone number you've provided him?
I do not, Your Honor. And I think the contact information they have is a phone. Now, they mentioned that they do not collect phone calls. I think Mr. Watts does have some money on his books to be able to make direct calls.
Right now, I don't. I'm having trouble getting money in. My parents have to come to town and put it on the machine up here, and it don't take but $100 a time, and they don't make it to town that much. So money is at times a problem to get, and I don't know for sure I don't have access to lieutenants or anybody of any authority in my pod. I'm in B pod, and have seen the last few days. Thomas has been around because she's on first shift. But anyway, I haven't seen her much at all until recently. I've seen her a couple times, but I'm not sure how I would get money on the phone to make a phone call that way.
And Attorney Watts, you weren't able to locate an address for this outfit?
No, Your Honor. I'm pulling up the website again here. The website does not have a physical address. As Your Honor may well know, arms list is essentially nothing more than essentially a classified ad, an online classified ad service. They are not and do not keep addresses of the advertisers there. All you would have would be an address of a corporate or a website for the website. I do not have a physical address.
Okay.
I would have to talk to them to verify they keep no records. Newspapers and everything keep records. I'm sure if the CIA, FBI, or something like that wanted the information, they'd have access to something. So I would have to hear that myself. I don't trust this James R. Watts attorney at all. You know as well as I do in the Bible, attorneys are the worst, evilest, and wickedest there are. They always trick, fool, deceive. I've had no luck with attorneys. I had them up at Chase County allow lies to put me in jail or prison for a couple of years. They aren't worth a damn.
All right, well, it sounds like Attorney Watts has attempted to provide you the information regarding that request. Defendant Watts. All right, the next motion I'll address is, it's titled Motion for Court Orders to Involved People that I have access to all of my required evidence for court proceedings and or trial. So you may make argument on that motion at this time.
Well, if you're saying we can't order it, I'll have to see about the subpoenas. It's going to cost in damages. Oh, I'll want at least $100 billion every word. And it's going to be paid in gold at $5 an ounce. Laugh that up. I determine what the price of gold is. And my cases from Chase County and Butler County before are still going on. They're tripling. Damages are tripling per day. They don't triple every day, but there's damages every day. It's add up every day.
What evidence are you claiming you have not been provided?
I purchased all those dang firearms through my phones, off arms list, and there was only one or two I purchased out of the Wichita Eagle. That bull barrel AR-15 in 2006 probably is probably in there, or might be the first of 2007. That bull barrel AR-15 DPMS was purchased out of the Wichita paper. They would have access to that ad. The rest of them were purchased through arms list. I'm not worried about purchasing firearms. You know as well as I do, there are no laws limiting felons from firearms. In 1930s, they established a National Firearms Act. When the United States went bankrupt, the bankers made them do that. That's stupid bullshit.
Well, Mr. Watts, what evidence?
I never will not have
question?
firearms. And I'm having machine guns. Two of those were fully automatics. I'm not dealing with this at all. So you'll have to execute me or whatever and send me to my angels, and I'll be back in 3 days and we'll just see what happens.
Right. Attorney Watts, have you been able to give Defendant Watts access to the discovery you've received from the state? And you're muted.
Your Honor, I have forwarded the discovery I've received from the state to Mr. Watts. In terms of the records and documents that I've received, they have all been copied and forwarded to Mr. Watts.
And Defendant Watts, have you received copies of that discovery?
Yeah, but we've already been through this. The things I need weren't in there, and they're just playing around. So it's purely satanic. You can tell what all's going on here. I've been through courts before.
Ms. Pierce, has your office provided the discovery that you have to Attorney Watts?
I believe we've provided everything. I did have, Bobby Albert with the sheriff's office go back and see if we could get some model numbers, serial numbers, things of those nature off of the guns. We have at least 20 guns. I don't know that all 20 of these were involved in the robbery, or if some of them were seized as part of a search warrant. As the court may or may not know, and I'm sure the court probably does, but there was a shooting incident that resulted in a search warrant, and some of these guns may have been taken as a part of that search warrant. I don't, Mr. Watts, the defendant's father did provide a list that was part of the initial discovery, I believe. And so I think that Mr. Attorney Watts did get that. I will resend this list that has the model numbers in case Mr. Watts didn't get that. And he can forward that to the defendant again, so that we make sure that he's got that. But I thought I had emailed that to him, but that may not be. I'll just redo it just so we make sure that we have it. And there's 20 something guns on it. And I have model numbers off of those. So I'll just resend that to Mr. James R. Watts, attorney, and he can forward that to the defendant.
Okay,
But
I don't know anything about a search warrant. I never received any search warrant. Where's that? I never received any information on how things went down after I allowed myself to be shot at the Leon Bank.
Are there search warrants that are part of this case, or is that part of a different case?
It's a different case, Your Honor. Those were conducted through the sheriff's office as well as the KBI as an investigation officer involved shooting.
All right. Well, Defendant Watts, it sounds like the state has provided to your standby counsel the discovery that they have, and he's stated here that he's forwarded to you what he has. So if there's other things that you're wanting to get, obviously you're representing yourself. That makes it a little more difficult to obtain those. We're trying to filter what it is that you're needing, and if it's something that the court can do, we'll look into it. But a lot of this stuff is things that are up to you to try to produce. So,
Like I said, I'll try the subpoenas. I've never, just for normal evidence, I had evidence delivered to me up at Chase County years ago. Didn't need subpoenas for everything there. But anyway, I'll go ahead and well, my parents aren't asking for stuff. They're old and might forget and don't get around very well at all. So asking them for stuff, I don't know. It takes them. When I asked my mother for the bank record showing my cash on hand, she said it'd take her a long time to get that. She wasn't in the shape to just go down and get it, that it would take her a while to locate the tub they're in, the plastic tote they're in, and then to get them out and get them copied. She said weeks. So I don't know how long it'll take them, but I'll see. She's about the subpoenas too, but it's going to take time. I haven't, like I said, I haven't had, for just this type of evidence, I haven't had to do subpoenas.
right. And the last motion that I have here that I show we have not addressed is a motion for me to be provided a full and accurate transcript of the preliminary hearing in the hearing of all motions prior to the preliminary hearing of October 1st, 2024 by October 25th, 2024 or before. Transcripts aren't generally produced in all cases. As a matter of course, they're expensive. If you have the funds to pay for a transcript, you can obtain those, but they're just not produced for free and given out.
They were at Chase County on my cases up there. I absolutely received preliminary hearing transcripts without paying for them or so on and so forth.
Well, this was a case in which you were present at the preliminary hearing. There are circumstances in which the court will order that a transcript be produced, but it has to be paid for. And if you have the funds to pay for transcript and want to get it, that's up to you, but I'm not gonna order it that it be produced, as it was a hearing that you were present at.
Yeah, but I need it in case people are gonna commit perjury or lie, whatever. So I'll have it, and I need to go through it and just see whether it gets transcribed properly.
That brings us back to the motion to continue the trial, and I'm not inclined to grant the continuance of the trial. This case has been ongoing now for a very long time. I think it's the oldest case that I've got on my docket, and it needs to be tried.
We'll be going for jury nullification. I have that right. You're just playing around. I told you before when you did this continuance, I went and get my evidence. You said we would address the motions later. Now you aren't giving me the time to.
We're addressing your motions, Mr. Watts.
Okay, I can't do the subpoenas in the time you're giving me now.
Well, I'm not at this time continuing the trial. We've got another court date, a pretrial conference scheduled. I believe that is January 31st at 9 o'clock. Jury trial is scheduled to begin February the 4th. So,
Your Honor, if I may,
go ahead.
I've mentioned this to Mr. Watts before. If Mr. Watts would provide me, either by letter or I can come out the jail, a specific list of who he wants to subpoena and what documents he seeks, I can put those subpoenas in the appropriate form and send them out.
All right.
You wouldn't get around to them right away, probably.
Well, if you could get to that sooner rather than later, Attorney Watts, that would be appreciated.
I'd like to know also, I forgot to mention, I'd like to know the cost of the transcript too, for that preliminary hearing.
Judge, I have no idea what the cost is. Typically, they're $200 to $400. It depends on the length of the hearing, of course, but I really don't know what it would cost.
Now, my parents, they'll refuse to give me the money to get that, and I have money coming in. So what do I do in that situation? I want a copy of the transcript.
Well, I think maybe we can look and see how much it would cost, but again, I think it will, they'd have to look and see how long it was. Would we have a couple hours in the prelim?
I believe so, Judge.
So, all right, Mr. Defendant Watts, are there any other motions you feel that the court has not addressed that you filed?
Oh, you've addressed them satanically, but you've addressed them. But no, it's just denying me evidence. God does not allow that at all. I don't care what the deal is. Nobody gets denied their evidence.
All right,
And
Ms. Pierce,
Either in
anything
jail
else?
or prison or anywhere.
Anything else from the state, Ms. Pierce?
No, Your Honor.
Attorney Watts, anything else?
No, Your Honor. And James, I will be happy to come out to the jail. Let's check calendar here real quick.
You see, I've got cell phones. There was a deal
It'll
on cell
probably be
phones.
tomorrow. If you can have a list of the items that you want sought and the persons who would have them, I will attempt to get a subpoena out to do that.
See, what you're going to do is, I'm not going to get the evidence until probably, if I get it at all, the day before trial or something that I can't prepare. It looks like it's jury nullification. I'm just going to pound that in.
All right, if there's nothing further, we'll be in recess. Thank you.